Well, good morning. Thank you so much for joining us for this breakfast seminar, which is going to cover a variety of topics connected to dishonest claims. For those of you that don't know me, I'm Hayley McLorinan. I'm going to be kicking off today's seminar dealing with the Criminal Justice and QOCS Act, Section 57, and an update on cases dealing with that in the last year, and a brief look at surveillance evidence. Sam Stevens is then going to provide an update on QOCS, and Helen Wolstenholme is going to look at committal. So turning to Section 57, it's early, so just to bring us all up to speed, just to remind you that of course that allows a court or requires a court to dismiss a case if a claimant is fundamentally dishonest in relation to the primary claim or a related claim, unless the claimant would suffer substantial injustice as a result. And it's now well established that the test for dishonesty is that set out in Ivey and Genting, i.e. subjective state of an individual's knowledge and belief of the facts, but then you apply an objective test as to what ordinary and decent people would consider dishonest. But that leaves the question of when dishonesty will be regarded as fundamental and when that fundamental dishonesty will be deemed to be related to the primary claim or a related claim. The authorities to date tell us that for it to be fundamental, it has to be determined that the dishonesty must substantially affect the presentation of the case. And it's also been said that dishonesty must go to the root or go to the heart of the claim. So the first recent case I'm going to look at is that of Kajanu and Essex Partnership University NHS Trust, a decision of Mr. Justice Ritchie in the High Court. And it's interesting both in terms of telling us when dishonesty will be regarded as fundamental and also considering dishonesty in the context of the schedule of loss. So the facts of Kajanu was that Mr. Kajanu was a pleasant chap who attacked his wife with a knife and attempted to murder her. And in the course of the ensuing fight, he sustained nasty injuries, cut injuries to his fingers. He was admitted to prison with those and ultimately attended the NHS and sought treatment. And he alleged that as a result in delay of treatment, that injury, the injury to his hand, resolved not as well as it would have done if he had had prompt treatment. So it was a professional negligence claim against the NHS Trust. The claimant was ultimately convicted of attempted murder, and as a result of that was due to be deported to Romania after his prison sentence. So his deportation was a relevant fact to the schedule of loss, which we'll come on to in a sec. Now, the trial judge made a variety of findings about fundamental dishonesty, which can be neatly summarised as, on the one hand, the claimant had not been honest about the cause of the injuries. So he had given an inaccurate description of the altercation with his wife. And the second area of fundamental dishonesty that was found at first instance was that the schedule of loss had been pleaded on the basis that the claimant would have remained in the UK and would have been earning in the UK after the accident, i.e. completely ignored the fact that he was going to be deported to Romania after his prison sentence. Now, the case at first instance was dismissed on the basis of fundamental dishonesty under Section 57, but an appeal against that was successful. And Mr. Justice Ritchie made 3 points, general points. The first was a finding of dishonesty by the claimant is necessary. Second, dishonesty relating to a matter incidental or collateral to the claim is not sufficient to amount to fundamental dishonesty. And thirdly, the dishonesty must have a substantial effect on the presentation of the claim for it to be fundamental. Now, in terms of the dishonesty about the cause of the cuts, what Mr. Justice Ritchie said was, it's really neither here or there. That was not something that the court needed to make a finding about. Because it was a clinical negligence claim against the NHS Trust, it didn't matter how the cuts were sustained. So the fact that the claimant had been dishonest about that was not central to the claim. It wasn't something about which the court had to make a decision. The relevance of his dishonesty was really only to his credibility. And what the court said was that Section 57 is not a credibility filter. all citizens are entitled to come before the court, whether they have a long list of convictions or not. And section 57 focuses on the claim and the matters fundamental thereto. So the takeaway in that respect is that if you are looking at whether something is fundamental, you should ask yourself, is this something that the claimant needs to prove to get home and succeed on their case? And in this case, how he got the cuts was not. Then turning to the schedule of loss issue, what the judge said in that sense, in that case, is that the schedule of loss hadn't been drafted by the claimant. It hadn't actually even been signed by the claimant, and the claimant had not sought to hide the fact that he was going to be deported to Romania in his witness statement. So this was a drafting problem about which the solicitors and counsel fully held up their hands and accepted that they shouldn't have drafted the schedule of loss on the basis that the claimant was going to remain in the UK in the future. Going forwards, and the takeaways for that, clearly there are going to be times when the pleadings could lead to fundamental dishonesty, but one has to look very carefully at where the line is between what the lawyers are responsible for and what the claimant themselves are going to be responsible for. So, for example, if there were unsustainable arguments made about carer rates, multipliers, mileage rates, for example, clearly they're in the province of the lawyers, whereas the claimant could clearly be fundamentally dishonest about other data that's relevant to the schedule of loss. And crucially, if that's repeated in the witness statement, that is where it's likely for fundamental dishonesty to bite. But if there is an incongruity between the two, then it's going to be more difficult. The next case I want to look at is Elgamal and Westminster City Council, a decision of Mr. Justice Jacobs in the High Court. And this is an interesting case concerning the interplay between exaggeration and fundamental dishonesty. The first instance judge had refused to make a finding of fundamental dishonesty, and that was upheld on appeal. This was a case where the claimant had sustained a nasty injury to the ligaments in the knee. And prior to the accident, he had been a successful parkour free runner and worked as a stuntman. And there was no dispute that he had got a genuinely nasty injury to the knee, and that as a result of that, he would not work as a free runner or stuntman again. But where the dispute arose was about his day-to-day activities. And the claimant was suggesting that there was interference with day-to-day activities, such as difficulty going up and down stairs, for example. He was suggesting at one point that he had a limp. And the defendant obtained surveillance, the high point of which was that on the day of examination by the defendant's medical expert, it showed that he was walking without a limp prior to the examination, and then during the examination, he was shown to have a limp. At later examinations, he didn't have a limp in during the examination. So there was an element of exaggeration that the court found, but the court found that that was not because the claimant was consciously or deliberately exaggerating, but nonetheless, objectively, there was exaggeration. Now, on appeal, the decision was upheld, saying that there was no fundamental dishonesty. And certainly it wasn't fundamental, any dishonesty that there was. And in fact, there probably wasn't dishonesty at all. It was an exaggeration. And actually, the trial judge hadn't found that there was a deliberate attempt to mislead. What the judge said is that where the dishonesty is alleged to have resulted in an inflated claim for genuine injury, it's necessary to consider the extent to which the dishonesty, if not exposed, would potentially have resulted in a higher quantum recovery. And here, the dishonesty did not affect the loss of earnings claim. Even with the surveillance, there was no dispute the claimant wasn't going to work on the same basis. The surveillance arguably impacted on the PSLA and care, but the court didn't think that it was to any great extent, and therefore it was not fundamentally dishonest. The takeaways from that is that we are often faced as personal injury lawyers with situations where the surveillance evidence will show that perhaps a claimant is, whether consciously or unconsciously, slightly over-egging the pudding, but that's not going to inevitably result in a finding of fundamental dishonesty, where it doesn't significantly affect the overall value of the claim. So another few cases that I want to briefly touch upon: Michael and I.E. and D. Herdford decision of Mrs. Justice Stacey. I raise this one just because it's a situation that I think is encountered by judges day in, day out, where you've got a claimant who comes to court, gives evidence in a second language, is frequently contradicting their witness statement, contradicting themselves, not following questions, not appearing to know that they are appreciating that they are contradicting their statement. And the trial judge makes a finding that the claimant gives the impression of a lack of understanding as to what's going on. And in this case, for example, the claimant was readily volunteering information that was not helpful to his case. So it gave the impression not of someone who was dishonest, but of someone or as someone who was deliberately trying to mislead the court. And there, a finding of fundamental dishonesty wasn't made, and that was upheld. So very commonly in these types of cases, you will have a situation where a claimant is not saying the same thing as is in their signed witness statement. But if the judge gets the impression that that's because perhaps they're not the brightest claimant, or they're really not following what's going on, then they're not going to make a finding of fundamental dishonesty. And that will be a sound decision potentially. The decision of Darnley and Cornish is an interesting contrast to Kajanu, because as in Kajanu, there was a lie about something which really the claimant didn't need to lie about because his case didn't stand or fall on it. Here, the claimant was bringing a claim for the cost of a bike that was damaged, and he lied about the fact that he owned it. Now, he would have potentially had a completely legitimate claim as a bailee, for example. He didn't need to lie about his status as ownership of the bike, but nonetheless, he had lied about it. It was fundamental to the case. In this case, it was fundamental because the bike was a valuable aspect of the claim, and therefore the claim was dismissed under section 57. So that provides a good contrast to Kajanu, and shows that even if the lie doesn't need to be told, if it's relevant to the case, it can found section 57 dismissal. Idden and Warner is an example that's useful of showing the type of case that will definitely be held to be fundamentally dishonest. In that case, the claimant lied about her sporting abilities after the accident. So she had flat out said that she couldn't do, or was extremely restricted in the sporting activities that she could do. And the defendant uncovered evidence showing her competing in very strenuous events, 10K runs, swim and run events, and this type of thing, in which she'd been actively competing. That was a direct lie that the claimant had made, and as a result, a section 57 dismissal was made. It had inflated the value of the claim, the judge estimated, from 70,000 to £1 million, and so clearly it was fundamental. And what the court said there was that the fact that the claimant had spent an interim payment on a new house and would have to sell it if section 57 was engaged was not a good reason for preventing section 57 from operating. Now, the final case that I want to touch upon in relation to section 57 is a recent case of Jenkinson and Robertson, and it deals with the issue of pleading of section 57, because of course we know that you don't have to plead section 57 to be able to argue it, but this adds a note of caution to that. So this was a decision of Mr. Justice Chowdhury, who set aside the trial judge's finding of fundamental dishonesty. Crucially, perhaps in this case, the claimant was a litigant in person, and prior to closing, a case of fundamental dishonesty had never clearly been put. So the counter schedule had said, for example, that the claims were speculative and remote, but had not said that they were fundamentally dishonest. Correspondence between the claimant and defendant from the defendant had referred to the claim being exaggerated and unreasonable, But when the claimant had asked for clarification of what was meant by that, the defendant hadn't provided any. And the result of all that was it wasn't until closing that matters of fundamental dishonesty were clearly formulated. And on appeal, it was found that the claimant was not given enough notice or opportunity to respond to allegations of fundamental dishonesty, although the court did not give any specific guidance on what should have happened in this situation. So, as we know, Mustard and Flowers, for example, tells us that you don't have to plead Section 57. So where does that leave us? I think the answer is that it's advisable to plead fundamental dishonesty at the earliest opportunity that you think you've got sufficient basis to found it. And that may well be in your final counter schedule of loss. But if it's not, and you're getting to the point of, for example, trial, maybe it's cross-examination where it comes out, particularly if you're dealing with a litigant in person, it may well be advisable to ask for an adjournment for you to clearly formulate your fundamental dishonesty argument. Of course, it has to be put clearly in cross-examination. But then, if you take an adjournment, write down what your allegations are and present that to the other side, whether in the form of a skeleton or otherwise, so that the claimant has the opportunity to address that. That is going to be advisable to avoid the situation, as in this case, Jenkinson, where ultimately the failure to clarify it meant that the Section 57 argument failed. So the final case I want to turn to deals with surveillance, so moving on from Section 57, and it's the case of Muyepa and Ministry of Defence. This is a case for late admission of surveillance evidence, meaning that the trial would have to be vacated. So what the defendant was saying was, at the time they served their counter schedule, they also served surveillance, suggesting that the claimant's claim was dishonest. The result of that, it was agreed between the parties, would mean that the trial had to be vacated to allow the claimant time to adduce evidence to answer the allegations that were now being raised. And the application was allowed, despite the fact it would result in the vacation of the trial date. So the facts of the case was that the claimant was bringing a £3.7 million claim resulting from a non-freezing cold injury, saying that as a result of the accident, he required lifelong care, his ability to work had been impacted, and so on. And then a couple of months before the trial, the surveillance evidence, which had been available for quite a long time, was served, which showed, for example, the claimant dancing at a barbecue and going about his day-to-day activities with limited restriction. Now, the judge reminded himself that he was concerned with whether the evidence could have a material impact on quantum, and where the claim was for lifetime losses, adjustments to the calibration of the degree of symptoms could have a very significant impact on quantum. So even though this wasn't a slam dunk piece of evidence, so for example, someone who said that they couldn't walk, in fact, was walking, it was more subtle than that. Slight differences, for example, in the amount of care that was required over a lifetime would be very significant. So this was clearly information that could be relevant to the ultimate assessment of damages. The court said it could exclude the evidence if it was an ambush, and there were two elements to that. Firstly, the claimant must have the opportunity to respond to it, which everyone was agreeing the trial would need to be vacated, so they would. And the second was the degree of culpability on the defendant's part, if the claimant's ability to respond or the trial date were put in jeopardy. As I say, the defendant needed to show that they weren't at fault for the fact that they had served their surveillance when they did. And as I said earlier, they had had this for some time. And at first, the judge was of the view that perhaps they should have served it earlier. But what the defendant argued and what was accepted was that until the completion of the schedule of loss, and again to the extent that the experts' reports fed into it, they were in no better position to assess how the final figures might turn out. nor be entirely certain that the claimant would maintain his claims at their highest following the completion of the experts' reports until the final schedule was forthcoming. So the defendant was saying, until we get the final schedule of loss, we can't be certain what the claimant's claim is, so it's reasonable to hang on to the surveillance evidence until that point, even though the surveillance evidence already showed a contradiction with the witness statement and what had been said to the medical experts. That was accepted and the trial was postponed and the defendant was allowed to rely on that surveillance evidence. Now, clearly that's a very helpful authority for defendants that want to hang on to their surveillance evidence, but I would urge caution with it, because it is clearly within the scope of a significant discretion, particularly when you're dealing with vacation of the trial date, for a judge to say, actually, no, you should have disclosed this earlier. The information contradicts what was said, for example, in the witness statement, which you've had for ages, or what was said in the medical reports that you've had for ages. And I'm not going to throw out and lose a trial date over something that you could have produced much earlier. So despite the decision in this case, if you've clearly got conflict between witness statements, for example, or earlier schedules of loss, defendants may well want to disclose their surveillance evidence at an earlier stage than the final counter schedule. With that, I'm going to hand over to Sam Stevens. Thank you very much.
I will be providing a summary and update on qualified one-way cost shifting, and the reason for this update is the relatively recent Supreme Court case of Adelkin and Hurl, in essence, this reduces the opportunity for cost enforcement by defendants, and so arguably places more emphasis on the exceptions to QOCS, and so it's a key case for both those advising claimants and defendants to be aware of. Let's first go over the basics of QOCS, and the provisions are set out in rules 44, 13 to 17 in what I think is remarkably brief form. Again, my personal view is that the rules are pretty poorly drafted, and that is a view that has been shared by the Supreme Court and a number of first instance decisions. And in Adelkin and Hurl, the Supreme Court did say that the Rules Committee should have a look at these, again, due to the amount of litigation that has arisen from them. So watch this space to see if there's any significant revision in the future. The key thing with QOCS is to distinguish two concepts, which may, after Adelkin, become a bit more confused, but they are still distinct. The first is orders for costs on the one hand. QOCS doesn't necessarily affect the court's discretion as to who pays whom costs. The second is the enforcement of costs, and that is primarily what QOCS is dealing with. It deals with enforcement. So this table sets out when QOCS does and doesn't apply, and formally it only applies to a claim solely for damages for personal injury or under Fatal Accidents Act legislation. Very briefly, if anyone is still dealing with accidents pre-1st of April 2013, always consider whether there's pre-commencement funding arrangements and the transitional provisions set out at CPR Rule 48.2, and pay special attention to this Court of Appeal case of Catalano and Esplitias. It's quite a niche issue which I don't need to deal with now, but just to put you on notice of that. This talk will essentially go clockwise around this table. I will first look at how QOCS applies to pure PI cases. I will then turn to consider what I say is the first potential exception, and that's proceedings involving claims with non-PI damages. We will then look at cases that have been struck out in certain circumstances, and then go on to cases involving fundamental dishonesty, but I won't recap what Hayley has already covered. And finally deal with claims for the benefit of others and Part 20 claims. Now, before moving on, it's worth pointing out two discrete points at this stage. First is that the rules specifically exclude pre-action disclosure applications from QOCS, so always bear that in mind. And the second is a recent decision of Her Honour Judge Clark, in Waterfield, which said that any pre-issue application, such as a pre-issue application for a GLO, does not have QOCS protection. It's not binding authority, but the reasoning is persuasive. And so worth bearing in mind if considering, say, an application for a GLO, as it might be prudent to actually issue proceedings first to get the QOCS protection. So the core protection of QOCS is set out in CPR 44.14 and subject to exceptions in 44.15 and 16. In summary, QOCS is a monetary cap on enforcement which is capped at the level of damages and interest that have been awarded to the claimant. Now, that seemingly innocuous provision has developed a significant number of trips to the Court of Appeal and one to the Supreme Court. It's clear that enforcement refers to standard steps to recover monies, for example, under Part 70. One issue that developed conflicting authorities was whether an application to set off a defendant's order of costs against a claimant's order, whether that was covered by QOCS. And in how an MIB, the Court of Appeal initially said no, set off wasn't a method of enforcement, that was part of QOCS. Now that had clear advantages for defendants in that it could set off a cost order, for example, where it had an order of interim hearing or a Part 36 offer had been accepted late, or even a low Part 36 offer had been beaten at trial. But in Adelakun and Ho, the Supreme Court overturned that decision, and in essence, the Supreme Court said it was refusing to become involved in any policy arguments on why set-off should be or shouldn't be included, but it held that the ordinary meaning of the words in the CPR meant that setting off against costs was a type of enforcement subject to the QOCS cap. Now, as I've said, the Supreme Court did suggest that the Rules Committee have a look at these provisions because of the arguable policy issues, and indeed one can see the policy issues. The decision in Ho essentially renders defendants' cost orders nearly ineffective unless the claimant has a substantial judgment or a relevant exception applies. So given costs is a way of maintaining good conduct in litigation, one can see how this could cause difficulties. So as I say, keep an eye out for if the Rules Committee comes to look at this in due course. So that covers enforcement, but what goes into the cap? That's been set out in the case of Cartwright and Venduct Engineering. In essence, any award of damage against any defendant in the same proceedings can go to increase the cap. Settlements, whether by way of Tomlin or Part 36, are not included in the cap. So a claimant ever settling in a multi-party case will always want to make that by way of a Tomlin or a Part 36 rather than a consent judgment to avoid any arguments on whether that goes to the cap or not. Now, all of that can be sort of explained in this illustration. Now, in the illustration, the first defendant has two cost orders, one for beating a Part 36 and one for an interim application amounting to £100,000. Now, it was a three-handed case and the claimant receives £100,000 overall. But because the third defendant settled for £25,000, that's not included in the cap. So the first defendant can rely on judgments both against the first and second defendant amounting to £75,000 and enforce their cost order up to that extent. It faces a shortfall of £25,000, which cannot be enforced against the claimant's cost order. That has to be paid come what may. So what points can we consider from this? Well, in multi-defendant cases, I think defendants should always keep tabs on what co-defendants are doing, particularly when there's been a discontinuance, because there's the potential in future to enforce that deemed cost order against a judgment against another defendant. Equally, for that same reason, claimants, when discontinuing in multi-party cases, may want to consider drop hands offers or the like, so that there isn't a deemed cost order in place. For defendants, the combined effect of Cartwright and Adelakhan is to take away nearly all of the arsenal of weapons and costs. But one point the Supreme Court did say in Adelakhan was that the perceived injustices of that decision could be dealt with by making submissions on the order as to costs itself. So, for instance, it may be submitted that the judge should take into account prior orders of the costs for the defendant when determining the claimant's cost recovery at the end of the action. Now, that's not yet been tested. It would be incredibly fact sensitive, and it would be appropriate to seek specialist cost advice on the issue, but do bear that in mind. I think the other thing as well is it's likely that when costs are at large like this, the want and the need to think about global offers, including costs, will increase as well. Let's turn then to one of the first exceptions, and that's for mixed claims. And the mixed claim is one involving personal injury damages and a claim for non-personal injury. So I have a claim at the moment, which is a straightforward clinical negligence claim, but it also involves a discrimination claim under the Overseas Visitors Regulations. Now, the discrimination claim isn't a PI claim, and so this is a mixed claim. And this is dealt with by 44.16(2)(b), and essentially it says that the court can give permission to enforce cost orders above the cap, but only to the extent that it considers just when there is a mixed claim. And this was considered by Lord Justice Coulson in the leading case of Brown and Commissioner of Police for the Metropolis. And what Lord Justice Coulson said in Brown is that the automatic QOCS protection falls away in mixed claims, but there is still this discretion, judicial discretion, to protect claimants arising from the words in 44 that we referred to earlier, particularly the underlined words. How does that discretion apply then? Well, Lord Justice Coulson's obiter comments essentially were to say, well, look at the case as a whole and stand back from it. And if it looks like a personal injury case, then say for where there's exceptional circumstances, such as exaggeration of the non-PI case, then the court will be likely to apply QOCS protection to the whole case itself. And so, for example, I had a paramedic case where the claimant had alleged that an ambulance was unsafe, causing personal injury. And they also brought in a reasonable adjustments claim under the Equality Act. Now, there was a legal argument as to the applicability of the Equality Act, and the remainder of the claim, the evidence that was put forward, was essentially the same as the Occupiers Liability Act claim. And I could have seen how the court may say, standing back, this is overall a personal injury claim. Turning then to the exceptions on strikeout, where a case is struck out for the basis list on the slide, QOCS will not apply. The first ground is there's no reasonable grounds for bringing the claim. The second is that the claim is an abusive process. And in broad terms, the third relates to where the claimant is responsible for conduct likely to obstruct the just disposal of proceedings. Now, that nearly mirrors the strikeout provisions in 3.4, but bear in mind that in 3.4, one can strike out a case for just a mere breach of the rules, orders, or practice directions. One has to go further in a QOCS case to disapply it and show that there's been an obstruction of the just disposal of proceedings. So both claimants and defendants should be careful on the wording of the order and what's found, and bear in mind that QOCS protection. There is an interesting appeal that's listed to go before the Court of Appeal, which I want to put on your radar. It's called Achillean Lawn Tennis Association Limited, in which Helen Bell of these chambers acts. And now in that case, the claimant brought a mixed claim. The defendant successfully struck out the personal injury element of the claim, but the non-personal injury element remained. And on first appeal, the claimant tried to argue that Rule 44.15 did not bite because the court had not struck out the entirety of the proceedings. Her Honour Judge Emma Kelly dismissed the argument, holding that proceedings in 44.15 was limited to the personal injury claim alone, and you didn't have to strike out all of the claims on the claim form. In my view, that must be the correct decision, but the claimant has been given permission for a second appeal by Lord Justice Coulson, which is due to be heard before March of next year. So keep an eye out for that. Where a claimant is faced with a strong strikeout application, it can choose to discontinue, and that is a reasonable litigation strategy to maintain cost protection. Of course, a defendant can apply to set that notice of discontinuance aside, but a few things to consider are this. Firstly, is the claimant good for the money? Secondly, how strong is the strikeout application? It would really sting a defendant to reinstate a claim and then lose the strikeout. And thirdly, what are the prospects of setting aside the notice of discontinuance? The court has a wide discretion to set aside the notice of discontinuance, but that must be exercised in accordance with the overriding objective. It's not necessary, but it will be helpful to point to the notice of discontinuance having been an abusive process. Now, this issue was dealt with by Mr. Justice May in Madden English, who held that there was no unfairness in a claimant discontinuing a case for the purpose of QOCS protection. He refused to set aside the discontinuance in that case, but suggested that where the claimant's behaviour was cynical or egregious, it may justify setting aside. So he has to make a careful judgment call. I think the relevant factors to consider are the strength of the application to strike out, the claimant's conduct to date, the amount of notice of the application to strike out, and the timing of the discontinuance. We'll deal very briefly with fundamental dishonesty because this has been covered by Hayley. A couple of procedural points. Fundamental dishonesty should normally be dealt with at trial, but the court can order a hearing purely to determine the issue of fundamental dishonesty. Where the matter has been settled, though, there must be exceptional circumstances for the court to order such a hearing. However, where the claimant has discontinued proceedings, no such exceptional circumstances are required. The court can list a hearing without setting aside the notice of discontinuance, and simply has to apply the unfettered judicial discretion to determine whether to do so. That was the outcome of the case of Alpha Insurance and Roche. Briefly on claims for the benefit of others, it's a very similar provision to mixed claims in that it's a discretion to disapply the cap essentially where it's considered to be just. It would apply to subrogation claims and claims for credit hire, for example, but it doesn't include claims for dependency, claims for gratuitous care, or subrogated claims for loss of earnings paid by an employer or medical expenses. The key point to take away from this is the decision of select car rentals and e-shore services by Mr. Justice Turner made it clear that this provision does not provide an extra power to order non-party cost orders. One still has to apply 46.2. And then finally, on Part 20 claims, it's a simple issue. Wagner in the Court of Appeal, it's clear that QOCS doesn't apply to Part 20 claims. And so defendants have a difficult balancing act to make with this, whether if they want to bring someone in, encourage the claimant to try to do it with the risk of a Bullock and Sanderson order, or do it via way of a Part 20 claim without QOCS protection and run the risk of having to pay third parties' costs. So obviously, a judgment call that needs to be made on the facts of the individual case. So in terms of final thoughts, defendants will need to make use of the limited tools available and pursue relevant strikeout cases where there's merit, properly investigate dishonesty if any hint of exaggeration, and stay up to date with the co-defendant's position. And I think Part 36 offers need to be made at the earliest stages if they're going to be made. And finally, claimants should consider drop hands offers on discontinuance in multi-party cases and discontinuing in good time following a strong strikeout application. Thank you very much. I'll hand over to Helen.
Hi everyone and good morning. I'm going to end today's session by dealing with what I consider to be the most powerful weapon in a defendant's armoury in dealing with a dishonest claim, which is committal proceedings. An application to commit a person to prison is obviously very serious, and it's likely to be deployed only in fairly exceptional circumstances. The procedures have to comply with their hearing standards, and the courts, as you would expect, proceed very carefully. It's absolutely crucial then to make sure that the application is made in the right way, with every I dotted and every T crossed, And I hope that my talk today will help you, if acting for a defendant, to do just that. So I'm going to start by looking at procedural matters relating to contempt proceedings, and then I'm going to turn to the very recent case of Hull NHS Trust and Colley, in which judgment was handed down only last month, and in which my fabulous colleague Caroline Harrison QC acted for the NHS Trust. It's quite a classic contempt case in some ways, but the facts bring the rather dry procedural issues to light. So first of all, as we all know, it's a contempt of court to engage in any conduct which involves an interference with the due administration of justice. That could be anything from disrupting court proceedings to failing to comply with a court order, or rather disobeying a court order. But in relation to our topic of the day, dishonest claims, crucially, it includes knowingly making a false statement in any document verified by a statement of truth. So that could be a statement of case, a schedule of loss, a witness statement, both pre-action and in the proceedings, a disclosure statement, and so on. Part 81 of the CPR sets out the rules relating to applications for proceedings for contempt of court. Now, you would be forgiven for having missed the fact that in October 2020, when we were in the depths of the pandemic, Part 81 of the CPR was very, very substantially revised. But at the risk of teaching grandmother to suck eggs, and I hope you'll forgive me, I can't emphasize enough just how important it is to consider the current version of Part 81 and to make sure that you're entirely on top of it, because it does massively change the procedural rules in this area. And just for example, one point to emphasize is that the nomenclature has changed. So no longer is it the case that we talk about applicants and respondents to contempt proceedings, but instead we talk about claimants and defendants. And that's possibly a bit confusing when, in a case like this, in the underlying proceedings, the claimant will now be the defendant to the committal proceedings, and the original defendant will now be the claimant to the committal proceedings. But there we go. So first things first, the application. CPR 81.3 sets out very clearly how to make the contempt application. I just want to highlight a few points. First of all, use Part 23 if there are existing proceedings. Use Part 8 if there are none, so where a claim is pre-action. But existing proceedings can be interpreted quite broadly, so that would include a case where the claim has been settled or discontinued. Also, the application should be made to the court in which the case is proceeding. So if it's in the county court, make the application to the county court. If it's in the High Court, it goes to the High Court. If it's in the county court, it's dealt with by a circuit judge. If it's in the High Court, it's dealt with by a High Court judge, not a master. And permission is required to make a contempt application in certain circumstances. And in particular, for our purposes, it's always needed where the application is made in relation to false statements. Now, Part 81 doesn't set out the test for whether permission should be granted. So the test remains based on the pre-2020 case law. The key issue isn't whether contempt of court has in fact been committed, but whether proceedings should be brought to establish whether or not that is the case. And on that front, the public interest is crucial. So a claimant will have to prove a strong prima facie case that the false statements, etc., were knowingly made and the defendant knew they were likely to interfere with the course of justice. But also the court must be satisfied that the public interest requires the proceedings to be brought. And there's clearly a balance to be struck here between the public interest, which is served by drawing the attention of members of the legal profession and the public to the fact that false statements will be treated very seriously, and that signing a statement of truth is not a mere formality. But on the other hand, the courts must be careful to guard against the discretion being exercised too broadly, and allowing vindictive litigants to use contempt proceedings to harass litigants. Secondly, the proposed proceedings must be proportionate. So here the court will consider the strength of the evidence, the amount of money that was involved. So the bigger the false claim, the more likely it is that permission will be granted. Costs and court time. And finally, the court will consider the overriding objective, as it always does. So if, for instance, the false statements have been retracted and a sincere apology already made, the court may be less willing to grant permission. Court may also consider factors such as delay. So how long ago was it that the false statements were made and the truth was discovered before the contempt proceedings were brought? So now, what must you include in an application for contempt if you're making one? Well, have a look at CPR 81.4. That tells you everything you need to know, and it's very prescriptive. So 81.4 is entirely new. It wasn't there pre-October 2020 in the CPR, and it essentially codifies, helpfully, the requirements that had previously been set out in the case law. So it sets out a list of 19 different matters that the written evidence in support of an application must include, and I've set out by way of example some of the requirements there on the slide. In essence, though, it's all designed to ensure that a defendant knows clearly what the allegations are that he or she faces, and that they have every opportunity to meet those allegations. So you've made the application. What happens at the hearing? CPR 81.8, again, very helpfully sets out exactly what to expect. So that the first point to make is that it requires that the hearing is in public, irrespective of the party's wishes, unless the court otherwise directs. And if the court does direct that it's to be held in private, then the Press Association must be informed, and the court must give reasons in public as to why it is going to hear the matter in private. So clearly the thrust and purpose of those rules are to ensure that it will only be in very exceptional circumstances that a hearing won't be held in public. And one can understand why that is, given that to justify committal proceedings at all, they have to be in the public interest. Somewhat unusually as well, CPR 81.8 specifies that at a hearing, the advocates and the judge will be robed. Again, that emphasises the seriousness of the hearing. The burden of proof is, of course, the criminal standard, beyond reasonable doubt, not the civil standard, balance of probabilities. And there, of course, there is a distinction with the fundamental dishonesty cases that Hayley has been talking about. And finally, the court will be slow to proceed in a defendant's absence. So if you're acting for a claimant, and you're concerned that a defendant might not appear, it would be prudent to be on top of the principles in Sanchez and Oves, which set out in what circumstances the court may proceed in the absence of a defendant. So factors a court might consider will be whether there is proof of them having notice of the hearing and sufficient notice, whether there's a good reason for non-attendance, whether an adjournment is likely to secure their attendance or not. They might have made it clear that they have no intention of ever attending, and so on. So if the court does find the contempt allegations proven to the criminal standard, the final stage is determination of the penalty. And on this point, the recent case of National Highways Limited and Hayatoan and others is worth a read. Now, that wasn't a case about dishonest statements. It was a case about the Insulate Britain protesters who, in October 2021, blocked junction 25 of the M25. The National Highways Limited sought an order that those 9 protesters had breached a previous injunction order and were in contempt of court. And the court upheld the application in relation to all 9 defendants and sentenced all 9 defendants to imprisonment not suspended of a duration between 3 months and 6 months. Whilst it's not a dishonest statements case, it does set out generally what the principles are when considering the nature and length of any penalty for civil contempt. And so it's of very substantial importance in this field. It makes it clear that the court can impose a fine or a sentence of imprisonment or sequestration of assets. And the discretion should be exercised to achieve the purpose of the contempt jurisdiction. So that's A, punishment for the breach, B, ensuring future compliance with court orders, and 3, rehabilitation. All the circumstances should be considered. So in particular, the court might consider the prejudice that was caused to the claimant or that may have been caused to the claimant or others, any pressure the defendant was under, whether the breach was deliberate or not, the degree of culpability, whether there has been any expression of remorse or a sincere apology given, not just any apology, but a sincere apology, and other personal mitigation. And in the case of the Insulate Britain protesters, the court specifically considered whether or not it would be appropriate to suspend the sentences, and found that it wouldn't be because there was no remorse expressed or any intention expressed in relation to the future compliance with orders. And just finally on punishment, in a case of dishonest statements, it's always worth citing these two authorities, South Wales Fire and Rescue and Smith, and Liverpool, Victoria and Khan, which are both cases involving dishonest statements, and both emphasise that committal to prison should be the usual sanction. So that's it on procedure. I want to turn now to the case of Hull NHS Trust and Mrs. Colley. You may have seen the coverage earlier this year. I have to say the Mirror and the Daily Mail in particular had a field day. And the background facts were very well publicised. So in short, Megan Colley was born with displaced hips, and she required several surgical operations during the course of her childhood. It was alleged that she had suffered a worse outcome than she would have done but for the mistakes in her care committed by the trust. The claim was initially pleaded at 7.3 million. It was alleged that Megan was significantly reliant on a wheelchair. She couldn't ride a bus. She had very limited walking capacity. She needed a wheelchair and special measures at college. It was accepted that she was by the time of trial doing a BTEC in performing arts, but it was said that her movement was limited to her upper body and head, so she wasn't able to dance properly. She also said that the course was for those with a disability, and that if she were doing a dance, she would be incorporated into the scene by lying on a table or sitting in a chair. Now, the Trust's orthopaedic surgeon expressed concerns about Megan's level of reported symptoms and said that they weren't explained on an anatomical basis. He also noted that the medical records suggested that she had a history of injuries when snowboarding, cycling, and playing hockey, which again didn't seem consistent with the case that she was reliant significantly on a wheelchair. So the Trust investigated. They obtained social media evidence, and they conducted covert surveillance. Now, the surveillance showed Megan moving normally, walking around town, standing for a very long period at a bus stop, shopping, even jogging with her younger brother at one point. The Trust then amended the pleading, pleaded fundamental dishonesty. In response, a revised schedule of loss was served of about 5 million. So there'd been a significant reduction in the claims for wheelchairs, but the claim generally was made still on the basis that Megan was significantly disabled, and it was said that the surveillance was taken on her good days and after she had had substantial quantities of tramadol. When Megan then turned 18, her mother was no longer the litigation friend, and 8 days before trial, Megan discontinued the claim. The Trust then shortly thereafter applied for permission to bring contempt proceedings against Mrs. Colley, Megan's litigation friend, and that was granted, the permission was granted. So in the contempt proceedings, Hull made very specific allegations of contempt relating to 3 different witness statements signed by Mrs. Colley and the first schedule of loss, which was also signed by her. Now, it shows just how careful you need to be in contempt proceedings. It's not like fundamental dishonesty, where you have to show that the fundamental dishonesty went to the heart of the claim or the root of the claim. But here, with committal proceedings, you have to be very specific about what the false statements were. So there were particular sentences taken from each of the statements that were said to be dishonest. The court considered the allegations over a 4-day hearing in February and March of this year. Evidence was given by Mrs. Colley and by a taxi driver who claimed to have taken Megan in her wheelchair to college every day. And on behalf of the trust, teachers from Megan's school and college gave evidence. Their evidence was to the effect that Megan didn't avoid dancing on the BTEC in Performing Arts. She was in fact a really strong performer who had been given the lead roles. So she played Nancy in Oliver. She played the princess in Sleeping Beauty. She played Jack in Jack and the Beanstalk. And there was actually footage from her various performances available for the judge to view. Mrs. Colley maintained her case that the claim wasn't dishonest. She said, for example, that Jack wasn't a main part in Jack and the Beanstalk, and Megan had rarely been on the stage. And she also said that she had relied very heavily on tramadol. And when it was put to her that what she was saying about the tramadol wasn't consistent with the prescription records, she said that she had been able to obtain tramadol from other sources. So this is just a picture that was part of the evidence before the court. So Megan is there, third from right, and you can see just it appears to be like any other performer on the course. So without particular disability and certainly not in a wheelchair in this photograph. So what did Mr. Justice Bourne decide? Well, he said it was absolutely clear that Megan by herself and with the help of Mrs. Colley, significantly exaggerated the levels of disability she was experiencing during the lifetime of the litigation. He said the most powerful evidence demonstrating that was the video footage of the various performances she had been involved in, and the evidence of her college teachers while she was there. He said that this makes a nonsense of the claim put forward. And he said he was sure that Mrs. Colley gave false statements in 2017 when confirming the accuracy of their experts' reports, and in the schedule of loss when stating that Megan was reliant on a wheelchair and out of the house. In relation to the argument that Megan had been captured on her good days, he rebutted this by saying that even if the dramatic performances represented her good days, I consider that the statements which painted a picture of very substantial disability on bad days and made no reference at all to good days were dishonest. So essentially it's dishonest only to give one side of the story. He declined, however, to find that the statements that were made in the earlier witness statements, so the ones from 2013, were false to the criminal standard, essentially because of the lack of contemporaneous evidence. So there were the college teachers and the surveillance footage related to the later period, not the earlier period, although he did say that he thought it was likely that they were dishonest. So that illustrates the significance here of the criminal standard of proof having to be satisfied, not just the balance of probabilities. And in terms of the sentence, it was 6 months imprisonment, suspended for 2 years. Now, you might think that in light of the Insulate Britain protesters case, the decision to suspend the sentence was somewhat surprising, given that in this case there had also been no apology and no admission of fault or guilt. But it's clear that Mr. Justice Bourne here thought that suspending the sentence was the right thing to do, because there was very strong personal mitigation from Mrs. Colley. So she had had a very difficult upbringing and a very difficult adult life. And he also noted that she had a younger child, a son who had his own medical issues, and that if she was sent to prison, then he would be very seriously at risk or harmed. So that's it then. That's all I have to say on contempt. I hope it's been useful, my talk as well as Sam and Hayley's talks today. Thank you very much for joining us. We hope that you enjoy the rest of this beautiful spring day. Thank you. Bye.